All right, let's get started. Welcome everyone to the Globalization Workshop. Alex and I want to give thanks first to the Mershon Center for generous funding of this workshop for umpteen years, I believe, and especially work by Aaron and Kyle and to make this happen. We're very, very pleased to welcome Professor Erik Voeten from Georgetown University. He's the Crow Professor of Global Justice, Geopolitics and Justice and World Affairs at Georgetown School of Foreign Service. And of course, a prolific author on topics in international law and international organizations, and of course, editor-in-chief of International Organization, where he's published among other places. And of course, he's going to talk to us today about the role of international courts, backlash, judicial restraint, and we're very pleased to welcome you.
Thanks, Sarah, and thanks, Alex, and thanks for the Mershon Center for inviting me here. So this is a project that's joint work with Øyvind Stjernsen, who is a PhD student at the University of Oslo, Pluricourts, where I also have an affiliation. And it deals with the question of how the European Court of Human Rights is responding to the backlash it has been receiving from liberal democracies within Europe. Now, the European Court of Human Rights is, of course, not the only international institution that has recently been facing this backlash from the traditional supporters of these institutions. And I'm more broadly interested in how international institutions respond to this challenge. So this is less about the causes of these challenges than about the response by international institutions to this backlash. And you can think of different kinds of responses, right? So first, governments could renegotiate these institutions. That's what Alex has been working on in the context of investment treaties, where you see governments renegotiating investment treaties to adjust to backlash that's coming against, especially arbitration rulings in the investment arena. But we also know that these institutional reforms are typically pretty hard to achieve, especially in multilateral contexts where some governments are interested in curtailing these institutions, whereas other governments are not. Or governments might just want very different things. The other ways in which you could see a response is if governments that are traditional supporters and have leverage over these institutions try to influence institutional behavior. For example, through the appointment process. So one example outside of the European Court of Human Rights is the WTO, where the United States has now been vetoing any appointments to the appellate body of the WTO, ensuring that by next year the appellate body will no longer exist because all the terms of the judges will have run out. So effectively, this nullifies the judicial impact of the WTO's dispute settlement understanding because you can just file an appeal when the appellate body can't hear the appeal because there's no judges to hear the appellate judges, right? So that's one form of influence over the behavior. It's fairly extreme. That doesn't exist at every institution, but we understand that this kind of influence happens. But another form of response, and one that I'm particularly interested in, is how international institutions can use their own agency to respond to these challenges. Right, so we have several theories of institutional behavior that argue that institutions themselves, through their own volition and their own agency, can have influence over outcomes. Traditionally, these theories posit that institutions do things that governments don't want them to do. They expand their reach beyond the original intent that governments have expressed in treaties. But you could easily envision the opposite kind of response, where an institution's environment changes, and in response to that changes in the environment, the institution feels threatened and actually accommodates the backlash against these institutions. And that's the particular context that I'm interested in here in this paper. So the example that I'm going to be talking about is the European Court of Human Rights, and I was realizing when I started preparing for this talk that I've only given this talk to law schools and to the European Court of Human Rights itself, actually, to the judges there, and I'm happy to talk about what they thought of this paper. But I realized I have to explain a little bit about what the court is and does. So the European Court of Human Rights is not an EU institution. It's actually an institution of the Council of Europe, meaning that it has 47 member states, ranging from Turkey to Russia, including all the EU member states. The only European state that's not a member of the Court of Human Rights is Belarus. what the court allows individual citizens to do is to file a claim that their government has violated one or more of the articles of the European Convention on Human Rights, and it's a convention that dates back to the 1950s. The convention spells out a very broad set of rights, including freedom, physical integrity rights, like freedom from torture, freedom of speech, privacy rights, a right to a free and fair trial in an independent court, a right to have your private property being protected. It's a broad range of rights that is being protected. The court was not that active until the 1990s, when states reformed the institution to help them deal with the transformation that was a result of the end of the Cold War. Basically, the integration of former communist countries into the rest of Europe. Right? At that point, the court, or all countries that were part of the court, had to accept its judgments as binding and give individual access to people to file claims before the court. And what the court can do is it can demand individual remedies, such as paying financial compensation to victims of human rights abuses, but also releases from prison in some instances. But it can also demand more general measures, including legislative changes. And the court has, over the years, come down with a lot of very high-profile rulings on issues as diverse as torture, like extradition of people to countries where they might be tortured, LGBT rights, like the role of homosexuals in the military, privacy rights, lots of property rights cases, lots of cases on court systems. So it's been quite active. This is not one of these international courts like the ICC or the ICJ that does 2 or 3 cases a year. This is a court that has about 50 to 60,000 applications a year that it has to deal with. Now, many of those applications are thrown out because they don't meet individuals first have to exhaust domestic remedies, and they need to have a claim that at least seems somewhat valid. But this is a court that comes down with many rulings a year, has been quite influential. But until quite recently, it never really experienced a true backlash. So states or governments sometimes disagreed with its rulings, but at least in the liberal democracies of Europe, there was broad support for the court as a whole. In fact, during the 1990s, all countries in Europe implemented the European Convention of Human Rights into domestic law. Right? And what that means is that domestic courts start interpreting international law and deferring very often to the rulings of the European Court of Human Rights on how the convention ought to be interpreted. So there was broad support, even if some individual rulings upset governments and they protested against those rulings, and sometimes they're very slow to implement those rulings. At least in the Western liberal democracies. But that has changed, and it really started changing in about 2005. Now, I hope people can see this. It's maybe a little bit unclear, but I love using British tabloids to make this point about how this changed, right? So the first real change was this guy. You can't really see him very well, but his name is Hearst, and he murdered his landlady with an axe, and then filed a suit from prison that he was unfairly denied his right to vote in elections. And the court said that indeed Britain's law that bans all prisoners from voting is a violation of the Convention on Human Rights. Now, actually implementing that ruling would be very, very easy. Because the court didn't say that you couldn't ban prisoners from the right to vote, but you just couldn't do it in this indiscriminate way. Right? You had to provide a rationale for why some prisoners shouldn't be allowed to vote. So, for example, those convicted of a felony, that would be fine. But in the British press, this was deemed completely inappropriate. And it actually came after some sort of domestic British judges had already given prisoners certain rights, especially rights of family visits and so on. So you got articles like this. There are human rights judges that are wrecking British law, and you can't really see this, but this was a front page article where they took pictures of the judges of the court, and there are 47 judges, and then had like little excerpts on why these judges were not really qualified to rule in British law. Some of them are these not really judges, or they come from tiny countries. Like, why should they be having anything to say about our case? And by the way, he's seen here smoking a joint. There's another picture on this front page with him having a glass of champagne. Yeah, so you have like the axe murderer who gets vindicated by European judges, right? And the implication here clearly is this would never happen if we just left it to the British judges. And you see all these other like very apocalyptic headlines emerging. So this is 2005. We're all doomed. It says here, and there's tons of others like don't meddle in our human rights, human right to make a killing. So this is about because all these prisoners, because the British government didn't want to implement this ruling, these prisoners kept filing suit and they got financial compensation because their right to vote had been taken away from them, right? So this article, by the way, is based on wrong facts, but that doesn't really matter. You get articles like this, their rights or yours, is this, are you protecting the rights of Dave or of a rapist or a killer or a terrorist? And notice the skin color differences there between their rights or yours indicators. 4,000 foreign murderers and rapers we can't throw out. So a lot of populist uprising over this. The enemies of the people headline is actually not about the European Court of Human Rights, but I put it up here because this was part not just of an uprising against the European Court of Human Rights, but against judges more generally, and judges having a big role in the policy-making process, right? So the enemies of the people is when the British Supreme Court said that the Parliament actually had to vote on the Article 5 exit, and so they're saying like out of touch judges who are defying the Brexit voters and trigger this constitutional crisis. Of course, the British Parliament voted for the Article 5 anyway. But this is part of a domestic atmosphere that was very hostile, not just to the international judges, but to judges in general. To this idea that there should be these counter-majoritarian people that are sort of interfering in British affairs. And of course, elites picked up on this. So Theresa May was Home Secretary, and she said, it isn't the EU we should leave the European Court of Human Rights and its jurisdiction. And she was particularly upset about these rulings that were that prevented her from extraditing suspected terrorists to countries like Jordan out of suspicion that they might be tortured there. So she wanted to extradite these people. The court prevented it. This is from the Justice Secretary, and I really, the important part here is the title of the article, which was, "Let us concentrate on real human rights." And that's an argument that the British especially made over and over again. Like, real human rights violations are not being committed in Britain, they're being committed in Russia and Turkey, and that's where the court should concentrate, not in our country. The one that really got to the judges, though, was, this guy, I gotta love the British. This is Lord Hoffman, and this is actually a picture from the article about the European Court of Human Rights. He was really upset about this prisoner voting rights ruling, and he gave a big speech in which he lashed out at the European Court of Human Rights and used all these cute British sayings. He said something like, "They're trying to teach grandmothers to suck eggs." I had to look up that expression, but I guess it means like he's trying to teach someone who already knows how to do it well. Like, you're trying to teach British people how to protect human rights, whereas we've been doing this for centuries. They shouldn't be doing this. And this hit hard with the judges in Strasbourg because it was a judge, right? It's a Supreme Court judge, not a politician, but a judge saying, we shouldn't have these judges in Strasbourg telling us what to do. And this was right after 2005. And they also started reform efforts. So this is a picture from the Brighton Conference. Britain was the chair of the Council of Europe and used its chairmanship to really propose a massive reform of the Court of Human Rights. They didn't get what they wanted. They actually just got some like soft law changes, changes in the preamble and so on that signaled some, that they wished for a greater restraint, but they didn't get the formal institutional reforms that they wanted. We see it in other countries too. This is from Switzerland. There was a call in Switzerland to have a prohibition on minarets being built. But a Swiss judge argued that would be a violation of the European Convention, so they started, the Swiss right-wing party started to mobilize against the court. This charming gentleman is the leader of one of the new populist parties in the Netherlands. He actually has a PhD in law. His name is Thierry Baudet, and which he wrote on the European Court of Human Rights, against the European Court of Human Rights, and he's now apparently like the third or fourth largest party in the Netherlands, if you believe the opinion polls. It's a big theme for him in his election appeals. It's from Denmark. This guy was supposed to be the master criminal in Denmark, and he was, at least according to the newspapers, and there was a controversy about whether he could be extradited to Serbia. So here's another effort, this time by the Danish government, to again try to clip the wings of the Court of Human Rights. Again, the effort didn't quite succeed. It's very difficult in these multilateral settings to negotiate. But they sent clear signals to the judges, like, we as liberal democracies, we don't want this court to interfere in our affairs. So my essential question is, were these signals successful, right? From the press and from Britain, from Denmark, from the Netherlands, from Switzerland, Austria, Belgium, were they successful in persuading the judges that they should be more restrained, especially against these well-developed democracies? Now, in a way, what happens here is not, the backlash itself is not entirely surprising. If there's one article about the European Court of Human Rights that IR scholars know, it's the Mershon 2000 piece, where he says, like, look, this Court of Human Rights is pretty useful for developing democracies to help them lock in their intention to reform and to improve on their human rights performance. It's not that attractive for authoritarian states, and it's not that attractive for consolidated democracies because they already have good protections at home, and this independent institution that can hear cases is just going to intervene in domestic affairs. So it's not entirely surprising that it happens. But the question then is, how do governments respond? How do judges respond? And especially, do liberal institutions like the Court of Human Rights have stronger incentives to respond to backlash from established democracies than from other countries, right? Because at the same time, the Turkish government and the Russians were also very unhappy about the court. Putin actually tried to poison the president of the court. Well, I'm not sure Putin did it himself, but he was at a conference in Russia and then came back home and had to be hospitalized with this specific kind of poisoning that was a case in London of the same poison. I forgot what it was. And there's other stories of very extreme pressure on the court from the Russians. But I'm going to make an argument that that kind of pressure is less likely to be effective on the judges than the pressure coming from consolidated liberal democracies. All right, so the first, I think, theoretically less interesting, but empirically interesting question is whether or not governments can influence the court through the appointment process. Like, if you're from the US, you think, of course, right? If you're a government, you have control over judicial appointments, and you change your mind about the court, you can just appoint judges and exercise more restraint. The way the appointment process works in the European Court of Human Rights is that every government gets to nominate a judge. Actually, you get to nominate a list of 3 judges. One of them is then chosen by the Parliamentary Assembly of the Council of Europe. These judges are appointed for 9-year non-renewable terms. Used to be 6 years, but now it's 9 years. There is a good bit of evidence that this is a political process. So the people I have up here is this Mr. Paulo Pinto de Albuquerque, who was appointed by the Portuguese Socialist Party, a very progressive judge. The picture I have up there is Mr. Friedrich Kilbro, is actually from the Faroe Islands, appointed by the Danish government. He was in charge of Danish asylum proceedings. And that was the big issue that Denmark had with the European Court of Human Rights, is their asylum rulings, because everyone who would be done with the Danish domestic legal process, if you're an asylum seeker, you're about to be extradited, what you do is you file an appeal to the European Court of Human Rights. And in the mid-2000s, asylum seekers won quite a lot of those appeals. And they were able to at least extend the process, but sometimes even stay in the country. The Danish conservative government was unhappy with it. He was the man in charge there, and then they moved him essentially up to the European Court of Human Rights. So you can influence this through the appointment process. I'm saying this is theoretically fairly obvious. Empirically, it's very controversial. If you talk to judges at the court, they are really unwilling to accept that sort of the political nature of the government sort of influences judicial behavior. So they're very willing to accept. If you ask them, like, would you be here if there was another government in power, would you be appointed? They would say no, but they still don't believe that it actually matters for judicial behavior. The Germans are very strong in this. So the Germans, Bundesverfassungsgericht, every judge is appointed by a political party. Every political party has a certain number of entitlements, of positions on the Bundesverfassungsgericht. They can appoint these judges, but the judges will tell you that doesn't affect how they behave. Now, as political scientists, we have a hard time believing that, and I think we should be right. But that's, at least among the judges, this is very controversial. This idea that sort of the political leanings of a government that appoints you might in some way be correlated with the behavior of judges, so I'll be testing whether that's going on. The second part, I think, is theoretically a little bit more interesting, but also empirically more difficult to demonstrate. And that is this question of whether judges have more of an incentive to respond to backlash from consolidated democracies than from other states. And I would argue that they do for a combination of reasons. The first is that consolidated democracies, especially compared to these sort of newer developing democracies, have less to lose in a way from leaving the court. In the sense that if Britain leaves the European Court of Human Rights, people are not necessarily going to question Britain's commitments to human rights or to democracy. And that might not be true for Hungary or for Poland. Right? That would be a much stronger signal that something is awry with democracy or human rights in Hungary or Poland itself. So they do have credible exit options. Moreover, the court depends on these consolidated democracies to a much greater degree. If you think about our theories about why states abide by human rights commitments, most of them rely in some way, shape, or form on the presence of accountability mechanisms, and especially some kind of reputational argument. And people make these arguments all the time. The fact that Britain was unwilling to implement rulings regarding prisoner voting, people argue, encouraged the Poles and the Russians to do the same. Because they could always point to the British as an example for doing exactly what they were already intending to do. For a system that is based on the premise that essentially there is a set of example countries, the consolidated liberal democracies, that are going to pull the other countries up to their level, which is really the motivation behind the expansion of the Court of Human Rights in the 90s, right? That this was a court that by binding sort of developing democracies to these stronger consolidated liberal democracies could pull these democracies up to that level. You need the consolidated liberal democracies in the system. A human rights court that only has these developing democracies in them is not going to fulfill that function as well as a court that also has the example-setting countries in there. And moreover, and perhaps most importantly, it is much less costly for the court, much easier for the court to accommodate consolidated democracies and to accommodate. So if the Russians come to the court, what they did actually in the Chechnya crisis was to say, if you don't calm down with your rulings here on Russian human rights violations in the Chechnya conflict, we're going to blame the court for this, that, the other thing. We're going to pull our support back and all those threats that they made. If the court gives in to those kinds of threats, it loses its legitimacy, very obviously, with its core supporters. Its core supporters are still in consolidated democracies, not necessarily governments, but also NGOs, especially legal NGOs that keep bringing cases, and other supporters that keep pushing governments to implement their rulings. So it's very hard, or well, not very hard. I mean, it really undermines the very mission, the very legitimacy of a court to give in to very obvious backlash from backsliding states or states that are simply not democracies. But accommodating democratic critics is not without cost, because some of the rulings that the court has taken have been accused, the court has been accused of backtracking, also by NGOs that are supporters of the cost. It's not without cost, but it can still be done while maintaining sort of the central mission of the court, which is to promote democracy and rights. Now, the way courts do this, I'm trying to argue this in the paper, is that it's very difficult for courts to do this by simply picking and choosing cases where they think political backlash is going to be likely, especially for an international court that doesn't always have very good information on what is going to be controversial in a specific country, or what is going to lead to a backlash in a specific country. This prisoner voting rights case that I mentioned earlier, I don't think the judges had any clue that this would be this controversial. They thought this was going to be a very simple, narrow ruling that would be easily implemented, and they did not foresee that it would create the kind of backlash that it did. When I talk to the judges, they tell me that they do try to infer whether something is going to be controversial. They read media reports. They understand that rulings on, say, immigration and so on are likely to be controversial in the current political climate. But they still often have a hard time. But what they can do is develop general jurisprudential techniques. The way lawyers work, you develop a jurisprudential technique or philosophy that has the effect of becoming more restrained towards consolidated democracies. And that's exactly what legal scholars have accused the court of doing. And I'm just going to give you an example of a ruling where I think you can see this very clearly. And essentially what I'm going to do is test this argument that legal scholars have already made. Right? Essentially, you can see this in the quantitative data. So this is a ruling from a case that is about France's ban on burqas. France is a burqa ban. We're banning people from wearing burqas in public. And in the ruling, the court says that the court essentially should exercise a degree of restraint when a balance has been struck by means of a democratic process within the society in question. And it also says here, on matters of policy on which opinions within a democratic society may reasonably differ widely, the role of the domestic policymaker should be given a specific way. This is a court, as you say here, like the court has already had occasion to observe that this happens. In general, a matter of general policy, when sort of opinions within a democratic society diverge, we should defer to domestic policymakers. So it's essentially saying, if the domestic policy process is democratic, give some attention to the convention, you're okay, we're going to defer to you. This doesn't apply when the process is not sort of similarly democratic domestically, right? So you see this kind of language emerging in rulings on consolidated democracies. You don't see this kind of language in rulings on Poland, on Russia, and other kinds of countries. When you talk to some of the judges, they say this has nothing to do with deference. This is just principle of subsidiarity. You can find it in other rulings of the court, and that's true, but it's been used a lot more in recent years against very controversial cases against consolidated democracies, and it's been expanded to really imply a degree of deference to, as long as the process looks democratic. And moreover, the judges on the court who do not agree with this, who are more activists, who want the court to really set a common standards for human rights across Europe, like be more universalistic in its approach, they have complained about this, right? So this is the Portuguese judge who had up there earlier in another case on prisoner rights versus the United Kingdom, where he says that this practice essentially leaves the door open for certain governments to satisfy their electoral base and protect their favored vested interests. Right? So this idea that the margins should be wider for states that are supposed to set the example for others than states who are supposed to take the example, the Poland and Hungaries of this world, is really just a way of sustaining or allowing governments to sort of satisfy their electoral support. And as a human rights judge and as an activist, he does not sort of normatively value this. All right, so what we're doing in this paper is we're trying to test these ideas. I'll go pretty quickly over this because I've already used quite a bit of time. But what we're doing is we collected this database of all the judgments of the court. We're estimating judicial ideology using ideal point estimation. Similar methodology that people have used on the U.S. Supreme Court, as well as on Congress, where you essentially estimate the ideal point of a judge based on the vote that they issue on a specific case. So we're looking at dissenting opinions here. In the particular context that we're looking at, all the cases are filed by an individual against the respondent government, and we've coded the direction of the vote in a way that you can't really do so easily for the Supreme Court. So we know that if the majority finds a violation and you vote against finding a violation, we define that as a vote on the more restrained side, whereas if you vote in favor of finding a violation whereas the majority does not, then we vote it in the opposite direction, but then we still estimate an ideal point model from that. And actually, I'll explain the methodology for the strategic deference when I get to that. I'll just walk through the results because I want to leave some room for discussion. But I'll explain the methodology when I get to those results. So what you get when you do these ideal point estimations is you get the names of judges here. They're ordered. On top are the more restrained judges that have more positive scores in this ideal point dimensions. You'll see fairly large uncertainty or confidence intervals. That is because I don't have a lot of votes for some of the judges, so it's fairly uncertain precisely where they are. But what you do see is sort of on average, a lot of the judges that have been appointed quite recently seem to be more conservative than others. So we see a trend towards the appointment of judges that exercise more restraint in their rulings than the judges that were appointed somewhat earlier. By the way, this is the most fun when I present this to the judges in Strasbourg itself, because they always are looking, and they always find like, oh, this looks pretty good, but I don't think I'm as conservative as you make me out to be. It's a common critique that I get, because I think there's sort of this common perception that as a human rights judge, that's not really where you should be. Like, where it should be somewhat more on the activist side. So we also find some evidence of polarization of the process. That is sort of, if you look at the ideology of the government in just left-right terms, we see a stronger relationship in more recent years than before. This is very imprecise because there's so few data points, so we don't have it in the paper, but we find some evidence that this sort of, it seems to be getting a little bit more polarized than it was before. I don't have the overtime change here, but you see we find some evidence, in short, that the judges are becoming more restrained. Now, however, the more interesting evidence, I think, to us is this evidence, is this question of whether the judges themselves are strategically deferring more to consolidated democracies than to other states. Now, this is obviously a very difficult question to answer. Why? Well, the kinds of human rights cases brought against Poland or Turkey are quite different from the kind of human rights cases brought against England or France. It's very, very obvious. So we will see differences in violation rate findings simply because of differences in the characteristics of the cases that are being brought by individuals. So we're doing two things. The first thing is we're looking at differences in differences. That is, we're looking at whether the difference between violation rates between consolidated democracies and other states in Council of Europe increases after the backlash begins in 2005 in the UK and in 2010s for the other consolidated democracies. Right, so what does differences in differences get you? Well, it leads to a valid causal inference as long as the parallel trends assumption is not being violated. And what that means is that there shouldn't be unobserved changes in the differences in the kind of cases that are being brought in consolidated democracies and not consolidated democracies. That's an assumption. Assumption we cannot really test, but an assumption we have to make in this context. The second thing we do is matching, just to decrease the model dependence of our diff estimation. That is, we want to really throw out all those cases that really could only come from countries like Turkey or Russia, or only come from cases from countries like the UK or so. Right? So the cases that have no parallel in the control group. And so what we do is we match on a whole bunch of case characteristics, like the article that the case appeals to. So for example, Article 10 here are freedom of speech cases. Article 5 are cases usually involving prisoner rights. Article 2 is right to life. Article 3 is torture. Article 8 is privacy cases. Article 6, free and fair trial. So we control for the kind of cases that are in the data. We also control for the applicants, so whether the applicant is a refugee or an immigrant or a prisoner. We control for the ideology of the panel, right, because we don't want this sort of difference that we observe in the ideologies of the judges to be responsible for our finding. We also have a measure of the previous experience of the legal counsel, right, because one difference could be that human rights, because we know that if you work with a very experienced legal counsel, you're much more likely to succeed in your case than if you don't. So we're looking at sort of repeat cases and how much experience and how much success the legal counsel has had prior to filing this case. And so we do coarse and exact matching. We've also done genetic matching. and the results are pretty similar. And we get pretty good balance, and we get pretty good balance both if we look at the two different time periods separately here as well. So that's hopefully sort of making our estimates a little bit more credible. So this is maybe kind of the key picture. So we're looking at the y-axis here are just the proportion of rulings in which the court finds at least one violation. And what you see is a clear sort of turning point around 2005, which is precisely when that first case hit and when, I didn't have that up here, like when another measure of media attention all of a sudden spikes in consolidated democracies, especially in the United Kingdom in 2005. It keeps expanding in the 2010s, and you see the gap between violation rulings against consolidated democracies and non-consolidated democracies sharply increasing after the mid-2000s. Right? That's kind of our key finding here. We do that here. So the left panel has no matching, just the raw data. The right panel has coarsened exact matching, and the same finding appears here. So the big finding is that this gap between violation findings between consolidated democracies and non-consolidated democracies increases sharply, where the blue line here is consolidated democracies. And these differences are large, right? They go from 80% violation rulings to about 60%, whereas here there's barely a decline in the control group of states. So these are fairly large effects when you think about the implications for applicants, right? So at least your success rate, if you're filing a case in a consolidated democracies, goes down by 20 percentage points. That's not insignificant. We estimate a whole bunch of models that are all in the paper. Unfortunately, the text is a little small here. So these are just sort of average treatment effects. Where we basically, what we do here is we take different time points, we construct different comparison groups. So in some settings, we're just comparing consolidated democracies within the EU to not yet consolidated democracies within the European Union, because even among the set of non-consolidated democracies, it's a quite diverse set of countries. But across all these settings, the effect is large. The effect is the largest for the United Kingdom. If we just look at the UK, we can even contrast the UK with other consolidated democracies. The UK is in the most local, and that's where the effect is the largest. So again, like we can't, it's not a airtight causal inference here, but this is, I think, the best we can do. And it's strongly suggestive of a fairly large change in violation rate. So again, we're finding most of these models around a 20 percentage point change, right? So these are large changes in violation rates. We also see that it seems to be increasing over time. So if you take the time points differently, I think that's also consistent. Just looking at different time estimates. All right, so I want to talk a little bit about implications, and then I'll stop talking because I've talked for a while already. The first I think is a bit of a normative question. So suppose we're right, and this is happening. Suppose the court is indeed becoming or exercising more restraint towards consolidated democracies than it was before. I suppose it's doing so in order to prevent future backlash. What does that mean? Well, on the one hand, you can argue this is a terrible thing because applicants, individuals, people who believe that their human rights have been violated, who would have won cases if they had filed in 2004, are not winning those cases in 2015 and 2016. Right? And so you could argue that the court is no longer doing its job. It's finding violations where it would have found violations in the past. And if we take the past as a good normative past, as some of the judges in the court would have it, then this is clearly something that harms the rights of citizens. We have some evidence that it might be more harmful, or that the court has been reacting more strongly against asylum seekers and refugees than against others, so it may harm the most vulnerable groups in consolidated democracies. Most of these cases are filed by prisoners, refugees, asylum seekers. So our findings could, in some of our estimates, we have up to 40 or 50 percentage points reductions in the probability of success for an asylum seeker over time. So that could be a normative bad. On the other hand, of course, it could be that this strategy is successful in keeping these countries in the court to begin with, credible exit threats, after all. And so that might have an overall positive effect on human rights in Europe. There's no real way to tell whether that's right? Whether if the court, if it had continued on its more activist streak, whether indeed the UK would indeed have left the convention by now. It's become part of the official Tory platform since 2015. It's not something that's just sort of out of thin air, not just something that's on the tabloids. It's actually a part of a policy platform. So perhaps that's worth it, and that's a difficult question to answer, exactly where that balance is being struck, because we don't know whether that's right. We don't know if the counterfactual, if the court hadn't done this, if it would have left the jurisdiction of the court. The other normative question here is that the court already has what is called like a living instrument interpretation of the convention. Those of you who follow the Supreme Court know what a living instrument interpretation is. It means that you observe changes in society, and the court itself reinterprets human rights language through the lenses of this interpretation. Well, we typically associate living instrument with the court becoming more progressive over time, right? But that's based on the assumption that society is becoming more progressive. If society is becoming more conservative, could you make an argument that it's normatively perfectly reasonable for the court to also swing in that direction? And I think that's an interesting question. I haven't seen that the question sort of being raised in this way so much, because there's somewhat of a hidden assumption in a lot of this work that society keeps getting more progressive, and that's the kind of trend the court should be responding to, but why not to an opposite trend? All right, and then the second set of questions, and I'll go over this, I'm happy to talk more about this in Q&A actually, is really sort of, are there broader implications for other institutions, right? Like what does this tell us about this end of the liberal order question? Because I think it's interesting, sometimes in this conversation we tend to treat these institutions as just passive objects of ire and of sort of deconstruction, if you want. But of course in our literature we've learned to think of these institutions as agents in themselves, right? So is it possible that they are actually acting to prevent the end of the liberal order? Are they active participants in this battle? And is this sufficient to keep democracies in? Well, I'm thinking, for example, of investment tribunals is an interesting alternative institution to look at. They're very different because they're not permanent courts. They're just tribunals, these arbitrators. There's some consistency in who they are, but they don't have a standing court in the same way. So it might be worked differently there, but it's at least I think interesting to look at whether other institutions are taking a similar approach. And then another implication that I had is like, I mean, if this is right, and if these institutions are more responsive to their liberal critics than their non-liberal critics, then we might start seeing that actually the liberal states are staying inside these institutions, but the sort of the more authoritarian critics are being forced out because their voices are not being heard the same way. All right, I'll stop here.